All right, let's jump straight into this explainer. We're unpacking a really fascinating, highly procedural legal paradox from a 2005 South African Constitutional Court judgment, Mtotywa and four others versus the Director of Public Prosecutions in Mtotywa. Now, I absolutely love examining cases like this because they show us what actually happens when the rigid, unyielding machinery of the legal system collides head-on with a person's fundamental constitutional rights. It's one thing to have rights on paper, right? It's entirely another when the court's own rules literally prevent you from enforcing them. So today we're going to break down exactly how this happens, step by step, and explore what it really means to get caught in a procedural trap.
Which brings us to the core question of our explainer today. Can you demand a do-over if you've already lost your final appeal? I want you to really put yourself in the situation for a second. Imagine making a shocking discovery that your original trial was fundamentally unfair. Maybe the evidence was tainted, or say your own lawyer completely failed you. But there's a massive catch. You only figure this out after you've already hit the absolute end of the legal road. What happens next? Are you just out of luck because the paperwork is filed, the final gavel has dropped, and the system wants to move on? Or is there a hidden escape hatch when your constitutional rights are on the line?
To truly understand this procedural trap and why it matters so much, we first need to look at the incredibly severe stakes facing the individuals involved here. We're setting the scene with 5 applicants sitting in Mtotywa Maximum Prison. Listen, these aren't people fighting a minor civil dispute or a parking ticket. These are human beings locked away in a high-security facility, fighting for their basic freedom and facing the very grim reality of spending the rest of their natural lives behind bars. The pressure here is absolute. Let's look at the actual numbers that put them there.
Back in July 2001, these 5 individuals were convicted of multiple severe crimes. And for the charges of murder, they were handed 2 terms of life imprisonment. 2 life terms. That immense sentence sets an incredibly heavy baseline for everything that follows in their legal battle. A single life sentence is devastating enough, obviously, but 2 concurrent life terms? That seals a person's fate in a way that makes the appeals process a literal fight for survival. But, incredibly, the sentencing didn't stop at life.
Because on top of that, they were additionally sentenced to a collective 71 years in prison. This 71-year sentence covered the rest of their charges, which included 4 separate counts of attempted murder, 4 counts of arson, and 1 count of assault with intent to do grievous bodily harm. All of these sentences were set by the judge to run concurrently alongside the life terms. So we've got 5 inmates looking at an almost incomprehensible amount of prison time. You can imagine the absolute profound desperation they must have felt to find literally any possible legal remedy to overturn this outcome. Tracking their journey gives us a perfect map of this long, exhausting legal battle. It starts with those initial devastating convictions in July 2001. After that, there's a grueling 3-year wait as they fight through the system, leading to a dismissal from the Supreme Court of Appeal in July 2004. Then, a whole year after that, in July 2005, they launch a sudden new attempt at what's called a special entry. And finally, it all culminates in a December 2005 Constitutional Court decision. To really grasp why that timeline is so spread out and why that specific gap between 2004 and 2005 is so critical, we have to look at how the courts themselves are structured. Think of the justice system as a ladder. These inmates spent years climbing it, step by step, hoping for a different result at each level. They started at the bottom rung with a single judge in the Mtotywa High Court, where they were originally convicted. Seeking relief, they appealed those convictions and sentences, moving up to the full bench of the High Court. When that bench dismissed their appeal, they didn't stop fighting. They reached for the next rung up the ladder, applying for leave to appeal to the highest authority for non-constitutional matters, the Supreme Court of Appeal, which is widely known as the SCA. And that brings us to July 2004. By this date, the Supreme Court of Appeal handed down its decision, and they dismissed the application. What this means in a strict legal sense is that the applicants had effectively reached the very top of the ladder. They had entirely exhausted their standard legal options. The regular everyday appeals process was completely, undeniably finished. As far as the procedural rules of the criminal justice system were concerned, the legal doors were shut, locked, and securely deadbolted. There was literally nowhere left to climb. But here comes the plot twist. This is what turns this from a standard criminal appeal into a full-blown constitutional showdown. After that Supreme Court of Appeal dismissal, the applicants simply refused to give up. They went out and hired completely new attorneys to review their file.
These new lawyers sat down, studied the cases from scratch, pored over the massive transcripts and records from the original High Court trial, and returned to their clients with some completely unexpected, game-changing news. The new counsel advised the inmates that their original trial lawyers had been highly incompetent and completely ineffective in their duties. The legal advice given to the inmates was crystal clear. Because of this terrible representation during that very first rung on the ladder, the original High Court trial, the entire proceeding had actually been deeply and fundamentally unfair. They hadn't just lost their case. They had been denied a proper, legally sound fight from the very beginning. The whole foundation of their conviction was rotten. So, armed with this shocking revelation, they went back to where it all started. On July 25, 2005, they returned to the High Court and applied for a special entry on the record under Section 317 of the Criminal Procedure Act, often referred to as the CPA. This is a fascinating procedural rule. It basically allows a court to formally record that a trial irregularity, in this specific case, the gross incompetence of their original defense lawyers, made the trial objectively unfair. It was the new lawyer's way of officially pausing the game to say, wait a second, we need to document that the foundation of this entire conviction was broken before we can move forward. However, the legal system relies heavily on rules, finality, and past decisions to keep things moving. The High Court threw out their application, creating a massive procedural brick wall right in front of them. To justify this firm dismissal, the court pointed to older precedent cases, specifically citing landmark decisions known as Cephasa and Mabinjana. The High Court's reasoning wasn't about whether the original lawyers were actually incompetent or not. It was strictly procedural. They relied on a very specific and unyielding legal concept that governs when a court's job is officially done. And the roadblock here came down to a legal concept known as functus officio. It literally translates from Latin to mean having performed his or her office. In practical legal terms, it means the court's authority on a specific matter has completely ended. The High Court ruled that it's simply not permissible to apply for a special entry at a time when the appeal procedure has already been completely exhausted. Once an application for leave to appeal against a trial court's decision is granted and moving forward, that original court becomes functus officio. It loses all jurisdiction to go back and make a special entry on the record. Returning to our ladder analogy, once you've climbed up to the top, you cannot turn around, climb all the way back down, and ask the bottom rung to fix a broken step. Their authority is spent. Their hands are entirely tied. Trapped by this strict procedural rule, the applicants found themselves in an incredibly desperate situation. They claimed this procedural block violated something far more powerful than the Criminal Procedure Act. They argued it directly violated Section 35, subsection 3 of the South African Constitution, which firmly guarantees every single person the fundamental right to a fair trial. They argued that without this special entry officially recording their original lawyer's incompetence, their trial was undeniably unfair, and therefore the conviction itself was unconstitutional. This clash between a rigid court role and a supreme constitutional right pushed them toward a desperate final move. They attempted an ultimate Hail Mary play. They approached the highest court in the land, the Constitutional Court, directly from the High Court. They sought direct access under Rule 18 of the court's rules, attempting to completely bypass the normal, much slower Rule 19 appeals process. Normally, the system demands that you go through the Supreme Court of Appeal first, before knocking on the Constitutional Court's door. But they were arguing that this constitutional issue of a fair trial was so pressing, so inherently damaging to their rights, that it needed immediate, urgent attention at the very top level of the judiciary. So the crucial point for the Constitutional Court became a serious matter of proper procedure and judicial hierarchy. The court noted that whether this was technically an application for direct access under Rule 18 or one for leave to appeal under Rule 19, the underlying request was exactly the same. The Constitutional Court was being asked to be the very first appellate court to consider the specific constitutional issue, entirely skipping over the Supreme Court of Appeal, without the benefit of a well-reasoned SCA judgment on the matter. And courts do not like to jump the line. They rely on the wisdom of the lower courts to refine the arguments before making a final binding national ruling. On December 14, 2005, the Constitutional Court delivered its judgment, firmly dismissing the direct access application. The ruling was uncompromising. They stated clearly, "The applicants do not show any exceptional circumstances. We could not find any." The court stated cleanly and directly that it was simply not in the interest of justice to grant direct access in this scenario. They explained it wasn't clear why the Constitutional Court was better placed than any other court in the normal course of the appeals procedure to hear the matter first.
Without truly exceptional circumstances to justify breaking the rules, the normal procedure must always apply, regardless of how high the stakes are for the individuals involved.
Which leaves us with this provocative thought to close our explainer today. If strict procedural rules, like a court being functus officio or the requirement to never skip steps in the normal appeals hierarchy, block you from proving your trial was fundamentally unfair, is true justice actually served? We know the legal system requires absolute finality and rigid rules to function efficiently. Otherwise, cases would simply never end. But when those rigid rules of court procedure trap a potentially unfair conviction, shielding it from ever being corrected, where does true justice lie? It's a heavy, enduring question about the delicate balance between systemic order and individual fairness, perfectly illustrated by the agonizing procedural trap these 5 inmates found themselves in.